let's give Ryan Kriegshauser a warm Pachyderm Club welcome.
Thank you all very much for having me. I really appreciate coming down to Wichita. I had some things going on down here anyway, so I'd have to stop off at the storied Pachyderm Club. I think the last time I'd been here was 2006, and so it's great to be back and visit with you all. And I'd like to keep this more of a discussion. I'll go through some of these cases and what I've been working on, but as questions come up, feel free to ask them. And I'd like to get through it as quickly as possible so we can have more of a discussion, answer some questions, because it seems like in these uncertain times, people, want to have more of a dialogue about what all's going on. So I want to provide that. All right, to establish my credibility as a lawyer, I need a good disclaimer here. So that's the purpose of this mostly, is to show that I am an attorney and I can write an adequate disclaimer. So there you go. And you heard some of my background, but what I want to really convey is that I'm a business lawyer primarily. I did corporate formation, capital formation. I'm a recovering bureaucrat, as you heard from my biography. I worked for the Office of the Kansas Secretary of State, and actually I was general counsel when the SAFE Act got passed. So I worked very hard on that voter ID law, as well as proof of citizenship, which is still tied up on appeal, as I'm sure you all well know. But the point of this is that I really wasn't focused on coronavirus. I kind of fell into it because I represent a lot of small businesses. But in addition to that, I prosecute on behalf of a rural county just north of Lawrence in Jefferson County. I'm also county counselor there. And so I saw the COVID issue from multiple directions. I saw it as a county counselor. How are we going to craft these orders? Should we craft these orders? What should they look like? What are the constitutional bounds of these orders? And then I looked at them as a prosecutor. Can we actually enforce these things? Can we prosecute them? What are the problems going forward with prosecuting them? And then in private practice, I looked at them on behalf of my clients who were small businesses that wanted to operate and were running into, at the beginning, local jurisdictions and then the power of state government ultimately. And so that's kind of how I got started in this, is working with small businesses, but it's not something I sought after. I just kind of fell into. And so take all my legal comments with that in mind, that it is the practice of law and I continue to practice. So that's why we call them legal theories, because we're in a novel situation right now. Coronavirus is new, and a lot of these things have not been tested. And so a lot of the things that we'll walk through here have been brought up in some cases, and some have not. But it is the practice of law, and nothing is a sure thing. And basically what lawyers do is help you assess risk. Is it likely that your claim is going to be successful, or is it unlikely? And so I've kind of listed these on my idea of success, given my experience. So these are the legal theories we've brought in different COVID cases. The easiest one to win, in my experience, is a pure lack of statutory authority. It seems, especially at the beginning of this crisis, local governments were not reading the law. They were trying to act quickly, and sometimes officials exceeded their statutory authority. The law says what you can and can't do. Just read the law, and that should tell you what you can and can't do. And unfortunately, in the emergent situation, particularly at the beginning of this crisis, that was not happening. And so we were able to seize on a lot of those opportunities that I'll talk about. Illegal rulemaking is another area that we've kind of explored. When you have a state-level dictate like a governor's executive order that is ambiguous and hard to interpret, and then you foist upon local governments the duty of executing that, they have to interpret things. They have to come up with ideas about what things mean. What is a bar? What is a restaurant? What is the difference between the two? And what we found is that local officials, sometimes low-level employees of county health offices, were making those distinctions. Well, I think you're not a bar unless you're not a restaurant unless you sell 30% of your annual revenue in food. Well, where's that written down? That we have a process by which we can do that in Kansas law. It's called rulemaking. The legislature says to an agency, you can interpret state law, but to do that, you have to go through what's called the Rule and Reg Filing Act, and it requires notice to the public that, hey, we're going to make a rule. It provides for a comment period that people come and say, hey, you're regulating my industry. Here's my perspective being in the industry. Here's what you need to take into account in making your rule. And then you have a hearing and you can have public discussion. And then, believe it or not, those rules are actually promulgated in writing so you can go to it and read what it says. Guess what local health officers were not doing? It was more pew, 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 pew. It was written down. It was just spoken word. And so we've seized on this idea of illegal rulemaking, and we'll get into some of those examples. Illegal delegation. This came up in Governor Kelly's case against the LCC, the Legislative Coordinating Council. And illegal delegation can happen in a number of different ways. And in that situation, the question was whether or not the entire legislature had delegated the role that the entire legislature could operate to pass laws to a smaller committee of the legislature. And the court didn't ultimately reach that because they didn't have to. They just interpreted the plain language of HCR 5025, and they didn't have to reach that. But this idea of illegal delegation comes up in any number of ways. For example, the enforcement of a mask mandate. The government isn't by and large enforcing that, it's private businesses. And so the government tells private businesses, you enforce this for me and take my executive power to enforce the law, and you private business, you enforce it on my behalf. I'm not gonna pay you, I'm not gonna provide you any liability protection. And what does that mean? I mean, what are the consequences of that? And so there are these theories of illegal delegation that have manifested themselves throughout the COVID crisis. Illegal search and seizure, and we'll get into some of those cases. This has come up during the COVID crisis, mostly in the context of contact tracing and that type of thing. Due process. When I first got into this was my quintessential, this is what's going on here. People are being deprived of a property interest without any right to a hearing. And so that both procedural and substantive, and we'll get into those cases. And procedural has encompassed vagueness in the criminal law context. Like what are these orders? What do they mean? What are the ordinances that you're enforcing in a criminal context? What is the law, and how do I know if I violated it? And what we've run into is a lot of this stuff is completely vague and arbitrary. And so that's an issue, as well as over breadth. And then we get to fundamental liberties. I'll get into some of those cases as well. Freedom of religion and freedom of speech have obviously come up. And then there has been some question, mostly in other states, about takings, taking property, eminent domain, Fifth Amendment type theories. But going back to the fundamental liberties question, Justice Alito spoke at the Federalist Society just a few days ago, and I found his comments very intriguing. I just read them this morning, so they're not in my presentation. I'll just read them off my phone. He said, basically, all I'm saying is this, and I think it's an indisputable statement of fact that we have never seen before the restrictions as severe, extensive, and prolonged as those experienced for most of 2020. It pains me to say this, but in certain quarters, religious liberty is becoming a disfavored right, Alito said. And that marks a surprising turn of events. Consider where things stood in the 1990s, and to me, at least, that does not seem like the Jurassic Age. And so I think Justice Alito is right. A lot of these questions are having a huge impact on our day-to-day lives, and I found his comments illustrative. So to get into some of the cases here, at least we have to provide a framework of how the law operates. So there's two sets of health orders for the most part. And the first I'll talk about are the local health orders issued by the local health officer. And at the beginning of the pandemic in mid-March, we saw a number of individual counties start imposing local health orders. And this created a patchwork effect. And there are three statutes primarily that the local health officers use. It's KSA 65119, the ability of a local health officer to limit or prohibit public gatherings. And then there's 65129, and it's a series of statutes that allow a local health officer to quarantine and isolate certain people. And at the beginning of the pandemic, you have to read the whole series. And county counselors apparently were not. To do that, to quarantine and isolate people, those people have a right to a hearing within 72 hours if they file a petition in district court. And what we were seeing is basically counties were putting their whole population on lockdown. They called them stay-home orders. These were mass quarantine isolation orders. So anyone in the county theoretically could go to a judge and get a hearing within 72 hours and say, Judge, this is not medically necessary and reasonable, which is the standard found in that series of statutes. And then a judge would have the opportunity to determine, and by the way, it's the county's burden. The county has to show the burden that this person must be locked in their home for an extended period of time, and that is medically necessary and reasonable. And the series of statutes says that in the quarantine order, it has to notify the population under quarantine isolation that they have a right to this hearing. All these early local health orders did not even mention the right to a 72-hour hearing. And so that's where we started this, is counties issuing these orders, confining their entire populations without fully reading this series of statutes. And then KSA 65202, which is basically the reservoir power that local health officers use to do all these weird orders. You see local health officers restrict school sporting events or curfews. You've seen any number of things that local health officers do that aren't completely confined in the limitation of public gatherings under 65-119, and they aren't quite isolation and quarantine orders. Like, where is the stay-home order? I think it's more isolation and quarantine order, but at the same time, they're also shutting down businesses. Where does that fit? It's kind of an isolation quarantine order in that I own a business, I can't go operate that business, I have to stay home. But at the same time, it's not directly a limitation on public gathering. You could argue that shutting down a business is just saying no one can come into that business. It's solely a 65-119 power, but it's really not either directly. It's kind of both. And so what local health officers have been using to justify these orders is this provision. It says, the local health officer shall use all known measures. And they say all known measures, and it goes on, to prevent the spread of any infectious, contagious, or communicable disease. So they say we can basically do whatever we want. It says all known measures. We can use anything. If that means demanding that a business log every single customer that comes into that business, who they're with, how long they're there, and then produce it on demand to an official with the local health department, that's a known measure. And we can use all known measures. And so, yeah, we can issue that order. And that's what they've been doing. And they've been doing it under criminal penalties under 65-127. The problem is, if you look at those statutes, there's something that's conspicuously obvious here. It mentions 65-118, 65-119, we talked about that, the limitation on public gatherings, 65-122, 65-123, and a lot of these have to do with the ability to exclude kids from daycare facilities if they're sick, or regulate funerals, 65-126. There's nothing in there about 65-202, because that would be the legislature giving to a local health officer unbridled power to make up crimes. Anything. I mean, all known measures. If I want to make an order saying you have to produce your business records, that's a known measure. If you assign a criminal penalty to that, the local health officer just created out of whole cloth a law with a criminal penalty. And so I think intelligently the legislature said, we don't want to include 65-202 all known measures in the criminal penalties provision. But a lot of these orders still include some kind of criminal enforcement provision. It has yet to be tested whether or not you can actually enforce these things criminally when they don't fit, nicely into 65-129 or nicely into 65-119 when you use these broad reservoir powers. So I call that the 65-127 problem. So when we started the pandemic, at the very front end, when these local health officers were issuing their local orders, Johnson County in particular issued one, and they had no religious exemption. And they defined mass gathering as including things like a drive-in church service. So this is a situation where people are all separately in cars, they drive in, and you tune your radio to a radio station, you can hear the pastor speak, or sometimes they had loudspeakers. And if you don't meet in person in church, this was an alternative. And here in Kansas, right at the front end, there were some churches in Johnson County that said, we want to do this. This is a way we can worship. And the county said, no, that's a mass gathering. And so We engaged on that, and thankfully they backed off. But Johnson County actually was ahead of the curve, and we saw this litigated in other states. On Fire Christian Center versus Fisher in Kentucky, and Temple Baptist Church versus the city of Greenville in Mississippi. And this is a burden on a fundamental liberty. It's a right to exercise your religion. And so they need to do that under a strict scrutiny. Is this a compelling state interest? And I think everyone would agree that the pandemic is a compelling state interest. I mean, government needs to control this thing, or try and attempt to do the best it can, but that is an interest that the government has. But then they have to narrowly tailor their ability to meet that compelling state interest so that it doesn't overly infringe on rights. Well, in the situation of a park and preach, I mean, it's ridiculous to say that people segregated in their cars are spreading the disease. Are you shutting down highways? People on their way to rush hour in traffic are just sitting in the exact same fashion. Of course you're not. What about Walmart? People sitting in their cars in Walmart, I mean, they're doing the same thing, maybe not for as extended of a period of time, but obviously this is not the narrowest way that you can try and prevent the spread of a disease and allow people to exercise their religion. And these were actually fairly easy cases for these federal courts to decide. And so we got out ahead of it in Johnson County and frankly in the state, because it was so ridiculous to have a county say, yeah, you can't do these drive-in services in a pandemic situation. And as we'll get to some of the later church freedoms cases that we got involved in, the governor actually cited this as an example of sophistication. She said, look, we're doing these park and preaches. It's amazing what we're doing here in Kansas. We've gotten ahead of the curve, and come to find out, no, they actually tried to shut that down on the front end. But anyway, those are facts, and you know. So then we get to the governor's emergency powers. And these, so you have the county level orders that started out, and then about a week later, the governor imposed the first statewide stay-home orders. And this is, those powers are derived from a totally separate area of the law, and that's the Kansas Emergency Management Act, KEMA. And the two main statutes that she derives her powers from under KEMA are KSA 48924 and 48925. And if you look at these powers, they're incredibly broad. She has the ability to control the ingress or egress of persons and animals to and from a disaster area, the movement of persons and animals within the area, and the occupancy of persons and animals of premises therein. And so, I mean, she has the ability to, under KEMA, issue stay-home orders under KEMA. And the question is whether or not it's constitutional or not. But she can require and direct the cooperation and assistance of state and local government agencies and officials. And then there's this very broad statement here at the end that the legislature amended in HB 2016, which we'll talk about here in a minute. And she has the ability to perform and exercise such functions, powers, and duties as are necessary to promote and secure the safety and protection of the civilian population. What does that mean? That's incredibly broad. And so she basically has cited this provision time and time again about whether she can issue a new disaster declaration, even if the legislature doesn't actually vote on it. Can she just basically roll out a new identical disaster declaration? Well, you know, it's perform and exercise other such functions. I mean, it's a function, and I believe it's necessary. And so, I mean, that's basically what the law allowed. It was incredibly broad, and thankfully that was changed by HB 2016, and it put in there that it's limited by the law and Constitution, and so the legislature did take that on. And so these non-compliance with these orders, the emergency orders by the governor, are criminalized by KSA 48939. So she did have the power to issue these, and it was a criminal penalty to not comply with them. But the legislature made changes to that as well, and they made it a civil penalty only, and basically provided the possibility of the state seeking injunctive relief instead of just going after someone criminally. So along with the first set of statewide lockdown orders, the stay-home orders, the governor put into place what was called the Essential Functions Framework. And this is not from the governor here in Kansas, CISA at the Department of Homeland Security talks in similar ways. And it really is, the CISA framework is really for the most dire situation you can ever imagine in the nation. I mean, this is for wars, this is for pandemics that have an 80% mortality rate. Basically, people don't want to leave their houses because there's a good chance that you'll die if you leave your house. And so CISA is more designed to say these are essential sectors of our economy. You have to go to work. You can't stay home. Get out there and work. It's flipping it on its head to say, you know, hey, I want to open my gift shop. Nah, you're not essential. I mean, that's not what it was designed for. It was designed to say these sectors of our economy we must maintain because people can't stay home without logistics, without things being delivered to their house, without going out and getting food. So those sectors have to stay open. Instead, in this situation, that was used to close down non-essential things. Whereas that would have worked itself out naturally in an incredibly dire situation. People don't want to leave the house. So we started investigating how they came up with this Kansas Essential Functions Framework, and through a Cora investigation, we asked questions of KDHE, the Department of Emergency Management, as well as the Governor's Office, and the Trust Kansas Coalition is a group, an association of groups that were interested in this, looking to a time where maybe there was another shutdown. And what we found was really astounding, is basically a group of 5 people, a few from the Governor's Office, KDHE, Commerce, and Emergency Management, led by a guy named Bill. And there was on the Emergency Management spreadsheet a column that said Bill's determination. Like Bill decided whether you were open or not. And what we found were a series of arbitrary decisions. And there were situations where a company wrote in and said, look, we have a 30,000 square foot warehouse. We've moved everyone home. Everyone's working from home. But we need one guy in the 30,000 square foot warehouse to just move product to those people. And he's going to be by himself. And to do that, we could save 100 jobs. Bill said no. Bill was like, no, you're not essential because you make acoustic cleaning supplies. Well, what does that have to do with it? There's no risk of infection, but yet this committee of 5 just decided, it's not essential. And so we aren't going to let you open. And then the other problem with the Essential Functions Framework is the governor's orders just included very vague wording, like restaurants versus bars, any number of things that just, they weren't defined, and so it was foisted upon local governments to provide those definitions. And a shameful plug here for the chamber. The KEF paradigm of essential versus non-essential, the Kansas Chamber suggested we should use a paradigm of safe versus unsafe. In this situation, CISA doesn't really work. People do want to go out of their house. They do want to open up their businesses. So how do we make them safe? Let's use operational risk management. Let's put in mitigating factors rather than just say, you make acoustic cleaning supplies. I know you have 100 employees and they may perceive their jobs as essential. We don't care about that. Even though you can operate safely, it's acoustic cleaning supplies. Instead, the analysis should be, I see you have a 30,000 square foot warehouse, one guy in it, there's no risk of infection. Proceed. I don't care if it's acoustic cleaning supplies. I mean, those people need their jobs. And so the Kansas Chamber pushed hard to say, this should be the interpretation here. This should be the way that we're going, and not this cold essential versus non-essential determination. So now we get to some of the cases. I don't know if you remember this. We represented 2 churches against Governor Kelly. This was right before Easter Sunday. We sent a letter to the governor's chief counsel, and we outlined the safety protocols we were going to put in place in these churches. We were going to socially distance. They were going to wear masks. They were taping off the pews. They were opening all the doors, having fans ventilating the facilities. They had a traffic pattern, so people were going to come in one entrance and leave, and so they could maintain social distancing the whole time. And the governor's order here targeting churches, because that's what it did. It targeted churches. Prior, the orders had made religious activity essential. She took that away and said those are no longer essential activities, and made special rules for churches. Basically, you could have 10 people besides pastors, choirs, and people on stage. 10 congregants. Everything else had to be virtual. And that only applied to churches. And we raised the point, well, office spaces and libraries are able to just basically have basic social distancing, and they can have unlimited numbers of people as long as they can socially distance. This is a completely new set of rules that you're just targeting on churches. And thankfully, federal court here in Wichita, Judge Brooms, agreed with us and issued a TRO. And through that process, the governor ended up backing away from that just direct targeting of churches and started applying the same rules to both churches and businesses. And now you see in a lot of these orders, there is no distinction between churches and businesses, and there shouldn't be. And so illegal delegation was first raised, and I talked about that a little bit, the Kelly versus the Legislative Coordinating Council. So that theory started prior to this case. This was primarily a First Amendment case. We did bring an equal protection claim, but the court really ruled on the First Amendment free exercise claim. And then I've talked about those other things there. So this was one of the first big pieces of litigation in COVID. And this is a case that followed not too long after. So through the series of reopening orders, we got in a situation through different business entities and a lot of like churches and private schools where we would find a situation where, say, churches wanted to have a service or, and it started out with churches saying, hey, here's our proposal for having an outdoor service during the reopening process. We want to have this many people attend. This is square footage. This is how we're going to socially distance. We're going to have a traffic pattern, and this is how we're going to enforce it. And we would get the counties to sign off on these things and say, yes, you can have your service. And this is after the church case, so there's no longer a distinction between religious and non-religious gatherings. And through the reopening process, I think it was the last reopening order, the governor applied different criteria to commencement ceremonies. And so what we had done, since we had gotten the counties to sign off on a number of these church services, we had a private school that wanted to recreate identically one of the things we'd already gotten approved for a church service. Same location, same number of people, same number of participants, same procedures and protocols. Only this time it's not a church service, it was a commencement ceremony. And so the governor was faced with this distinction between, wait, you've already signed off on this church service and said it was okay, but now we're calling it a commencement and it's not okay all of a sudden according to your order. And so we had walked down this path of, you can't even justify this with a rational basis. What makes the exact event different because you called it something different? If the things are truly identical, the people involved are identical, and not long after that, she abandoned her reopening plans. I don't know if you remember this. She was going through a reopening process, and finally it got so ridiculous, I think they were looking at it and saying, we can't continue. And they just foisted it upon the counties at that point, and it was just astounding that they just kind of abandoned these reopening plans. And so not long after that, this case came up because you had the state order, and now we were back down to these county orders. And so this was a gym in Johnson County that they wanted to open, and it was a fitness center. It was a very boutique type of studio. They had a very specific clientele, and the governor's executive orders allowed businesses to repurpose to meet essential functions. So you could be a gym and not open, but if you repurpose to meet essential functions, you could be open, according to the governor's executive order. And so that's what they did. They repurposed. They started focusing their clientele on essential functions personnel. So they focused on surgeons and people in the medical community. They started taking post-rehabilitative referrals from doctors, people who needed to build muscle after surgery, and they focused on that kind of clientele. They started selling supplements. They started refocusing their classes more on community health and wellness. All these things were in the essential functions framework, and they said, we have repurposed, we are meeting essential functions, we are opening. And Johnson County came back and said, that's not how we interpret the governor's executive order. And this is really where this idea of illegal rulemaking came from. What power does the local health officer have to interpret the governor's executive order. Now, he can issue his own local health order, and as long as he provides enough definitions, that's one thing. But that's not what was happening here. You had the governor's executive order, and then a local health officer without any of the requirements of the Rules and Reg Filing Act, no notice, no comment, no hearing, just saying, I don't interpret it the same way as you. So the essential function says train and educate essential functions personnel. Hey, we have a police officer, he's essential. We're teaching him Pilates. It's training, it's education in Pilates. Now, I acknowledge you might think that's ridiculous, but does it meet the letter and the words in the executive order? Yeah. And I'm sorry you don't interpret it to mean we can teach a Pilates to a cop. But that's essentially the fight we got into. And so we actually sought a 72-hour hearing in Johnson County, and Judge Haber in Johnson County started looking at the lack of due process in this whole situation and said, and he didn't have to issue an order, we had a hearing, and he basically asked Johnson County to work with us and come up with some level of due process, and ultimately they were able to open. Just when we engaged in that dialogue, when we showed them the safety protocols that this place put into practice. I mean, they put in high capacity air movers that were cycling air through their studios every 2 minutes. They had misting technology to sanitize. I mean, they were going above and beyond. And once you can explain that and show that story, it becomes impossible to say you can't open even though you put all these protocols in place, but we're cool with Walmart, when they don't really do anything. Next, we come to an illegal search and seizure case. So this was down in Lynn County. Lynn County decided that their local health officer issued an order saying, every business in Lynn County, you need to track every customer that comes in, who they were with, how long they were there, and that needs to be producible on demand by any employee of the local health officer at any time. So anyone from the local health office can just show up to your business and say, I want your list of people. And so we sued them with the help of the Kansas Justice Institute. They were involved in this case. And we said this is a warrantless search regime. And there's no pre-compliance review. There's no requirement for a warrant, and there's no requirement for just going to a neutral officer of some type to say, I don't want to produce this list. Will you review it and let me know if I have to produce it? There was nothing like that. It was just on demand. And we claimed that it violated the Constitution. And then this question of could they actually issue that order with criminal penalties started showing up, because the 65202 problem, they were issuing these orders under the all available means rationale. And we said, oh, that's all well and good, but you can't try and go after these businesses with criminal penalties. If they don't want to give you the list, you can't assess criminal penalties if you're using truly 65202 only. And so that's when this started coming up. And what we found is in these situations where, once you get into the details of it, the counties don't really have a leg to stand on. They just back away and change their order, which the local health officer can do at any time. If you don't like the order, I get sued on it. The next day I can change the order and, hopefully it's better. And that's what counties have been doing when they're called on things. They just change the order and try and get on down the road. So this case also never came to an opinion, because after they were sued, they just changed the order to take out that search regime. But they didn't keep doing it, which is kind of the point with a lot of these things. This was a case in Emporia. The gym is a bar. It's not a gym. It's just called the gym. But they opened up under the theory they had a food license. They sold food, and the county had decided they were a bar, even though they sold food. And restaurants could be open, but this bar that sold food could not be. And so the owner said, I am a restaurant. There's nothing saying I'm not a restaurant. You haven't given me clear definitions of what a restaurant is. And they actually issued him a citation. And I don't think there are many criminal attempts to prosecute some of these shutdown orders, but this was one where they actually were moving forward in a prosecution. So we took them on and filed a motion to dismiss. And what we found through this whole process is it was really complicated how they got to their enforcement of this, because they had passed a city ordinance that basically made the violation of a health order a crime. And we're seeing more and more cities do this. But the problem was the county commissioners had never really issued a health order. They issued a declaration of emergency that incorporated not the governor's executive order, but one of these reopening plans that really had no legal force or effect. And so really there was no violation of anything because they hadn't issued an order. And so our first argument was they lacked any statutory authority because they didn't really have any order that anyone could understand that he had violated. But even beyond that, this idea of what is a bar, what is a restaurant is unconstitutionally vague. I mean, it's up to him to decide. I mean, he's given no guidance. He sells food. What's really the difference between the two? And the Flint Hills Community Health Center, an employee of it, had issued the determination that this was a bar, not a restaurant, because 30% of their sales weren't derived from food. And that was her assessment that she just came up with. And we said, that's an illegal rule. That's not written down. That's not in the governor's executive order. Where are you getting that other than your mind? If this is allowed to have a local health officer or employee come around, what if I'm a teetotaler and I just decide, you know what, alcohol's bad. I don't want any alcohol sales in my county, and I have godlike powers to enforce my will. Well, I go around and I say, if you sell a drop of alcohol, you're a bar. Hey, I get to make the determination, no alcohol sales. If you sell alcohol, you're a bar. Otherwise, you're a restaurant. And I mean, that's the regime they were setting up. And so anyway, needless to say, this was dismissed without a response to our motion to dismiss. And now we get into some of the more national cases, and I'm focusing mostly on Kansas, but I mean, there's been some pretty interesting cases nationally. I'm talking mostly about the successful ones, and I should say that for every successful case, there are 10 to 15 unsuccessful cases. In the pandemic, most of the cases brought by businesses against shutdown orders are not successful. Most of the church cases we see across the United States are not successful. California, you just see case after case after case that is not successful. But this is an interesting one in that it was successful. And Pennsylvania, and I don't know if any of you have heard about this case, but federal district court in Pennsylvania determined that Pennsylvania's life-sustaining versus non-life-sustaining paradigm was unconstitutional. They had brought a number of different constitutional claims, including a takings claim, which I always find interesting when Fifth Amendment claims are brought, and the court pretty much dispensed with that one right off the bat. And this case basically said that this did violate due process and it violated equal protection under a rational basis. So this court actually said that you have a legitimate state interest, but the things you're doing have no rational basis to trying to fix those things that you're claiming an interest in. And so I found this really fascinating. Now, I don't think it'll stand up on appeal. It's already been stayed, pending appeal in the Third Circuit, but it was a pretty fascinating case in that it was the first case that I saw that actually challenged a life-sustaining, non-life-sustaining paradigm that was actually successful. And so thought I'd bring that up. And then this one is very interesting from a Kansas perspective. So this was the governor of Michigan, and a district court certified to the state Supreme Court 2 questions on state law. And basically, there was a situation where the governor of Michigan tried to extend the disaster declaration, and the legislature said, no, we're done with this. We aren't extending the disaster declaration. So she said, well, I'm reissuing the identical one. I'm just issuing a new one, but it's the same one. And so she got sued, and the federal district court asked the Michigan Supreme Court, does she have the authority to do this? And they basically said no. That circumvents the entire reason for the Emergency Management Act. And these same types of provisions and questions have come up in Kansas. Our legislature has extended the disaster declaration, and there's a number of reasons they have done that here in Kansas. But the question had always been asked, what happens if they don't? And if the governor just decided to issue a new disaster declaration, what would happen? And so this case actually delves into that question, at least from a Michigan perspective. And in Michigan, they also had an act that we don't have here in Kansas. It was the Emergency Powers of the Governor Act. And basically it said that in certain situations, if there's an emergency, the governor has these sua sponte, like very broad powers. And so she argued that she could just use those to issue emergency orders. And so there was an argument about whether or not that was meant for very localized disasters. And the Michigan Supreme Court actually found that the entire Emergency Powers of the Governor Act was unconstitutional because it had no definition to it. And so it was actually, it's a fascinating case, and one that could come up if the governor here in Kansas just decides, if the legislature doesn't extend the disaster declaration, she issues a new one, some of these issues could come up. So I thought I'd mention that one. We continue to see across the state these issues with school boards. We've seen a lot of them in Johnson County, not opening up to in-person school. And this came to a head in Blue Valley, and I was involved in some of those issues. And so what happened in Blue Valley is you had a school board appoint a gating criteria committee that then applied gating criteria to determine whether or not to open schools. And the school board never came back and ratified those decisions. And so the question was brought up, okay, well, if you had the authority, and the school board never really voted to appoint anyone, we didn't really know who was on the gating committee. They didn't really vest them explicitly with authorities. And so the question was brought up, well, if you have the authority to make these decisions, and one of the big decisions that came up was how to rank these, how to weight each of these criteria, because there were 5 criteria, and there was discussion about how some should weigh more than others. Like hospitalization rate should weigh more than percent positivity rate, because at the time there was discussion about the percent positivity was unduly high because we're only testing sick people and people who had come in contact. So that's artificially high, so we shouldn't weight that as much. And so this gating committee just decided to weight them all equally. And so the argument was, that's a policy determination that had to be brought up to the board, or at least ratified by the board, and they didn't do that. They did it in secret and just issued an email the next day saying, hey, virtual school and no sports. And so we actually filed an Open Meetings Act complaint saying that either this committee had no authority and acted improperly, or they did have authority and weren't subject to open meetings and no one could come in, and they should have been because they're making policy determinations. And the district attorney said it wasn't on the side of the Open Meetings Act, so they were advisory only, but yet they acted and they took official policy action without ratification, and that ended up in federal court, and it was actually just dismissed a few weeks ago, because what we find in a lot of these cases is when plaintiffs bring them, the school board will dump all kinds of money into defending it, and the plaintiffs run out of money. And I think in this case, in the federal case, they filed a 60-page motion to dismiss, and the plaintiffs are a whole bunch of parents that kind of came together to try and fund this thing, and they just couldn't sustain it. And so that question is unanswered. The Johnson County District Attorney said it's not an Open Meetings Act violation, so the question is, did they take unauthorized action? We don't know, because that never came to a full decision.
Take a couple questions.
Yep. No? Oh yeah, are we out of time? Man, that flew by here. But yeah, we'll cut this off and take some questions. There are a few other cases here, but yeah. Yes, sir.
My question in regards to regulation on churches. What happened to the separation of church and state we hear so much about? If that's a reality, how can the state regulate the church in any way?
Yeah, I think the pandemic situation is different. There's a case called Jacobson versus Massachusetts that comes up in every single one of these cases, and it's a vaccination case. But basically, the bottom line is that the state will always assert that this is an emergency, this is a pandemic. So the police powers have the ability, the state has the ability to protect the citizenry, and those powers go beyond the normal situations, and that's basically the state defense on almost all these actions is pandemic, Jacobson, we win. And that's basically the argument that has come up time and time again. And unfortunately, a lot of courts are willing to, after the fact, say, yeah, that was probably constitutionally too far, but in the midst of an emergency, in an emergent situation, they defer to the executive branch. And, I mean, it's just the way of things. And so it seems like nationally, courts have been deferring to the executive and people who are trying to deal with this emergency. And that's what's been happening.
Two questions. One is, who decides what an emergency is, and is there some standard for that? And the second one is, how come nobody brings up freedom of assembly in these complaints?
Well, to answer your first question, so the governor can declare a disaster, and she can do that for any number of things, wildfires, tornadoes. But then that is in place for a certain amount of time, and then the legislature has to sign off on it if they're in session. If not, then the Legislative Coordinating Council, she has to have some kind of legislative buy-in to extend it. So that's how the decision is made. I mean, she could come up and proclaim a disaster for any number of things, and actually governors proclaim disasters all the time for snowstorms. And as long as she can get some legislative buy-in to continue that, that's the question. But she can determine what a disaster is. Whether or not, how long that goes, depends on whether or not she can convince legislators to go along with it. And so that's the answer to your first question. As far as the freedom of assembly, that has come up. One of on the car case slide with the park-in preaches, there were a series of car parade cases that particularly Kansas Justice Institute got involved in. And I don't think they ever had to file any actions, but this is situations where it's senior year and all the parents for whatever high school want to get in a car parade and go celebrate their kids graduating because, they're locked down and otherwise they can't celebrate these graduations. And cities were actually saying, no, you can't do that. And so Kansas Justice Institute sent basically threatening letters saying this is a freedom of assembly issue, this is free speech issue, and to my knowledge, every one of those cities backed right away and allowed those car parades. So it is being brought up, whether or not it's litigated, and that's a problem with a lot of this stuff is it's not coming to decisions. We aren't getting courts of appeals decisions because the municipalities and the counties are backing away, and there's no resolution. And unfortunately, the last pandemic was in the early 1900s, and if you look at a lot of the case law involving quarantine and isolation orders, the questions are, for a pestilence house, does it have to have a roof for you to throw someone with smallpox in there? It probably should be habitable, should probably have a roof because it's early 1900s case law. There's no case law about how it works today. And so, unfortunately, we aren't getting a lot of those decisions right now. But I'm sorry, I should have spoke faster.
Well, thank you. You're speaking very interesting stuff, so don't apologize for what you already did. I have a comment and then a bit of a question. I think most everybody in this room who I have a current email address of had gotten about a month or two ago this email about using L-lysine and vitamin C to keep from getting COVID-19. I wasn't here for the last 2 weeks because 2 weeks ago I went to the VA hospital, waited in the waiting room half an hour, and then it was first, before they took care of my chest cold problem, they said, do you mind if we give you a test for COVID-19? I said, sure, but I'm sitting beside 2 people here that are sick and 3 people over here that are sick. I'm probably, and the test they gave me was the long toothpick with the cotton swab, so it's just a test for exposure. I tested positive for exposure. So then right away some people were saying, your L-lysine is not working. But it did work. For 2 weeks I've tested 4 times a day, temperature both ears, and I did not get it. So I want you to know that the L-lysine and the vitamin C does work in that I had exposure proven and I didn't get it. So the question is how do I inform the state, or how do we let people know that really better than wearing a mask is taking 125 milligrams of L-lysine along with an orange or grapefruit or vitamin C?
Well, like in a lot of these cases, I mean, I've actually tried to stay away from. I'm not a doctor. I can't tell you, this thing or that thing really works about preventing COVID, or isolation works or doesn't work. I've mostly focused on what the law allows. And so, I mean, as far as informing people, I mean, you just did it. You know, use the platforms you have to get it out there, and social media is one of them. But yeah, other than that, I've tried not to talk about the medical efficacy of a lot of these things because I don't know. You know, so yeah.
Yeah, they've taken our income and they've closed our businesses. They told us we have to wear a mask. Do they have the power to tell us we have to take a vaccination?
Well, I mean, I think that'll probably end up being litigated, but Jacobson v. Massachusetts is a vaccination case, and it had to do with whether or not you had to get a vaccination to send your kid to a particular school in a particular situation, and it's over 100 years old. And so does that apply now? I mean, I guarantee that will be litigated if they try and force a vaccination on folks, and so we'll see what the courts today say about it. But yeah, I think Jacobson was in 1905. And that's been a lot of the criticism about a lot of the case law in this situation is it's old.
Which way did it go?
Huh?
Which way did that 1905 case go?
Yeah, that they could require vaccination to go to a public school.
It could.
Yeah, in that situation, but this is obviously a broader situation. If you're saying you can't go out and live your life in public, generally going about your daily life without a vaccination, that's a very different question than I want to go to this publicly funded school, and to get that public benefit, I have to have a vaccination. So it's kind of a distinction there. But yeah, other questions?
Hello there, and thank you for being here. The Kansas Emergency Disaster Management.
Yeah, KEMA,
Yeah.
the Emergency Management
From
Act.
my reading of it, there's you can only imply one state of emergency for 15 days with one extension of 30 days.
Mm-hmm.
So even reading the Californias, we differ. So I'm told we have loopholes that Cal is using. So what are my loopholes to change this or reverse this?
Well, I mean, talk to your legislators about that, because she has been issuing slightly different disaster emergencies every time. Like first it was the coronavirus, and then it was the economic fallout from coronavirus. So she alters it a little bit to have new disasters. But really your legislators are who you need to talk to about that. The legislature had the Kansas Emergency Management, a special committee on it, just here that met a few months ago to talk about amending that act, and I think you'll see significant amendments. You saw significant amendments during the special session with HB 2016. I think you'll see that continued here in January when the legislature comes back. I think a lot of policymakers are very keyed in on that, and so that's the best way to get them to make those changes for you. So yeah, other questions?
Ryan Krieghauser, let's give him a round. Thank you.
Yep, thanks for having me.